Okay, good afternoon, everybody, and welcome to our Fieldstone4U. We have our friend Ron Brand, who's going to answer all of your employment-related questions. And I'd like to welcome Janet Buck with First Republic, who is our corporate sponsor. So we're so grateful to both of you for your participation with the network and your belief in the nonprofit community, because truly without you, we wouldn't be as strong as we are. So thank you to both of you for your time and your energy and your expertise. Today is kind of a loose event in that we didn't put anything formal. We just thought we'd let Ron talk and then answer questions of the group. So if you have questions, I'm fine with you putting them in the chat, or if you want to just raise your hand, just literally raise your hand and then Ron can acknowledge you. And he can answer questions. We have 16 people in, so we're not going to do introductions. It's a big group. But if you could just mute your phone so that we don't hear any background noise, I'd appreciate that. Ron said he'd give us an hour, so we'll see if we need the whole hour. I have some questions as well, but mine will only come if you don't ask those questions. So again, thank you. As Robin and I have said all along through these webinars is, you asked and we listened and we put together a webinar, and employment law seems to be kind of top on everybody's mind. So we're grateful that we have Ron, who has agreed to do this. Now this is his second time, and we had kind of brainstormed about this and said, questions that you have today are going to be very different than what they looked like probably 2 or 3 weeks ago. And I imagine 3 weeks from now, you'll have some new questions, and maybe we can twist Ron's arm to do it again in maybe another month. So without further ado, I'm going to turn it over to Ron. And if you wouldn't mind, Ron, just again, introducing yourselves for the folks that were not privileged enough to join you the first time. Robin has created a YouTube account. So she'll put the link in the chat if you haven't already done that, but she'll put the link in the chat so that you have it, and then you can come back on and you can look at all of the webinars that are in the library, and today's will be added to that. So Ron, it's all yours.
Well, thank you. Thank you for having me, and thank you for taking the time out of your busy day to spend about an hour with me. I'm a partner at Kahana & Feld, and I've been practicing labor and employment defense for 20 years. And so I represent businesses, both profit and nonprofit, in all areas of labor and employment law. So I'm here today just to answer any questions you might have about labor and employment issues related to the COVID-19 pandemic. I'm sure you have a lot of questions about what you should be doing vis-a-vis opening up your workplace. That's a big area that I've been dealing with over the past few weeks. But I'm here to answer any particular questions. If you want, I can just talk about some things. So I'm here at your beck and call. So if anybody has any questions, feel free to shoot them my way.
Can I ask a question? This is Ligia I have a question. When we are ready to bring back employees, as we furlough approximately 100 of them, what seniority does an employee with works compensation has? Do we have to bring that employee back because he or she is on works comp? What is the labor code on that?
Is this employee on workers' comp because of COVID-19 or some other type of workplace injury?
Prior to.
So there's no requirement that you give seniority to an individual who is off of work on workers' comp. You have to treat that employee the same as you would treat any other employee. So if there are legitimate reasons why other employees would be brought back to work first before this other employee, that's fine. So again, just treat the employee on workers' comp like you would treat any other employee. So that's kind of the general answer to your question.
Thank you.
So Ron, if an employee has been furloughed and they refuse to come back to work when you tell them that the office is open, how do we deal with that employee?
That's a very good question. I get a lot of these questions from my clients where employees who have been furloughed and they are getting more being furloughed from unemployment insurance than they would from actually working. especially when you throw in the $600 that the federal government is giving to people who are off of work each week, people can make $4,000 a week being on unemployment insurance. So what I've been telling my clients is that if you have work available, you request that the individual come back to work, and if the individual refuses to do so, then I think you can take the step of terminating the individual. If the individual is refusing to come back to work, and the only reason is that the individual wants to stay on unemployment insurance to get more money. Now, how many employees would actually say that? It's not often, but a client of mine did have that situation where the employee said, you know, I'm making more money on unemployment insurance, so I'm not going to come back to work now. And in that situation, the client terminated the employee because it was clear. Not only that, that would technically be fraud. And the EDD, the California Employment Development Department, they actually have a fraud hotline, either by phone or online, that if you suspect that an employee of yours is committing employment insurance fraud, you should contact them. So you just need to make sure that that's the reason why the individual is not coming back to work, because the individual wants to get more money being on unemployment insurance. So you really need to dig deep a little bit and find out exactly what the reason is why this employee is not coming back to work.
And then I understand that there are some states that are saying that if the employee refuses to come back, that person then is not eligible for unemployment moving forward. And I don't know where does California stand on that?
Yeah, I don't know what the laws on that specifically are, at least outside of California. I don't know what all the ramifications are if an employee engages in unemployment insurance fraud, but I can certainly see one of the ramifications being that the employee is not entitled to unemployment insurance. Yeah, but I don't know the specific rule around that.
Okay.
So when they go back to work, does the employer have to contact EDD to let them know they're back employed?
Well, typically the employee would let them know, but nothing prevents you from contacting the EDD as well. Absolutely. Now, there would be a requirement if you receive some type of notice from the EDD asking you what the status of this employee is. But if you don't get that notice and an employee does return to work from unemployment insurance benefits, then I would contact the EDD to let them know.
And would your answer apply to the reason I'm not comfortable to return yet?
Probably. So here's the rule around that. Employees cannot refuse to come to work simply because they're afraid or concerned about something happening in the workplace. They can refuse to come to work if the threat is imminent to their health, safety. It has to be a significant imminent threat to their safety or their life. And so I don't believe the pandemic has risen to that level yet, because the chance of contracting COVID-19 at work is still relatively small. So employees technically cannot refuse to come to work because they're concerned about contracting COVID-19. Now, with that being said, there might be some individuals, like for example, older people who have underlying medical conditions. It might be prudent not to have them come back to work, especially if they can work at home remotely effectively. So I wouldn't have a blanket response to saying, oh, you're concerned? Sorry, you have to come to work. I would try to figure out each situation, because maybe there is a legitimate concern, but generally speaking, employees cannot refuse to come to work simply because they're kind of scared or concerned about something. There has to be an imminent threat to the safety, health, or life of the employee.
My husband's been on unemployment because he works at Disneyland, and you have to certify benefits. So every day that you didn't have a job, so as soon as they come back to work, you wouldn't certify those days, and you would just drop off of unemployment. So I would think that it's their responsibility, not yours.
That's correct. It is their responsibility technically. If you have any concern about it, though, you can certainly contact the EDD. Nothing prevents you from contacting the EDD. I mean, they have a hotline for employers as well. So,
Ron, I see in here, Kathy Selig has a question. What if someone in the household is high risk, but not the employee?
Now, is that question in relation to the issue whether the employee can refuse to come to work?
No, Kathy, are you on mute, Kathy?
Yeah, I'm here. Yeah, what if someone doesn't want to come back to work because someone in their household is high risk? They are not, but they're afraid they might get something and take it to someone in the household.
Yeah. So look, the same rule applies. However, I encourage my clients to don't have a one-size-fits-all approach. Talk to the employee, find out what's really going on. If the employee is able to work remotely, effectively and productively, then maybe you should allow that employee to work remotely. So take each situation on its own facts and try to figure out what's happening. So I wouldn't have a blanket rule that says, oh, if you're concerned about coming to work, sorry, you have to because you don't meet the standard of refusing to come to work. I would have that standard in the back of my mind, but see if you can try to work with the employee to try to alleviate that employee's concerns. And if at the end of the day, the employee refuses to come back to work and the employee can't work effectively and productively from home, and this employee is important to the functioning of the business, then fine, terminate the employee at that point, but try to figure out a solution if possible. I mean, in fact, the Department of Labor says, with respect to the Families First Coronavirus Response Act, try to work with the employees to come up with some type of an accommodation if possible. And I think that serves the employers better if they try to cooperate with the employee and try to come up with some solution. It just makes them look better in the future if the relationship goes south and the employee decides to sue. You want to make it seem like you've done everything you could to act fairly and reasonably. Anything else? Sharon, you don't have a question for me? I've worked with Sharon for many years at Habitat for Humanity. So, and she usually has questions for me. But maybe she's not hearing me. I don't know. Is anything else?
Hi.
Oh, hey, Sharon.
How are you?
I'm doing well. How are you?
So, I'm doing well. So one of the things that's come up recently in some conversations is liability forms and whether we should encourage some document that basically says the Habitat is not liable if you get sick, etc. Specifically for volunteers. And it was more based on the question about bringing volunteers back into the fold than staffing. But then I've heard just the opposite, that they probably don't want to go down that path. So what's your thought on that?
Yeah, I have a lot of clients of mine that want employees to sign, these liability waiver forms that if they get sick with COVID-19, that the employer is not liable. I don't think those are enforceable. You could have employees sign it, but I don't think it's going to be enforceable for a couple of reasons. One is if an employee gets sick or injured at work, the employer has the legal obligation through the workers' comp system to provide benefits to that person. And that's not something that can be waived. That would be against public policy.
Right.
And Governor Newsom issued an executive order a few weeks ago saying that from maybe April through
Sorry.
It's okay, no problem. That if an employee contracts COVID-19, it's going to be presumed that it was contracted while at work, and therefore workers' compensation benefits would apply. That is the flips of what it normally is. Normally, the employee has an obligation to prove that the injury occurred at the workplace in order to be covered by workers' compensation. But now, with respect to COVID-19, I believe at least through July, could be longer, that if an employee gets sick with COVID-19, it's going to be presumed it was contracted at work, and therefore workers' compensation benefits would apply. So I don't think those releases are going to work. Some of my clients still want to use them, and I say, fine, go ahead and use them, but recognize that there's a good chance that it won't be enforceable. And then what if you have a situation where an employee refuses to sign it? Are you going to fire the employee for refusing to sign it? That's very sick, that's very concerning to me, that a company would fire an employee for refusing to sign a release of liability relating to COVID-19 when under California law, the employer is obligated to provide benefits for workplace-related injuries. So through the workers' comp system. You know, the workers' comp system essentially was a trade-off. So before the workers' comp system, employees would sue employers for injuries that occur at work under like a personal injury claim, negligence claim. And in that situation, the employer could have been held liable and maybe had to pay a lot of money if they could show that it was kind of reckless or gross negligence. And so with the workers' comp system, employers, they obtained the benefit of not being sued because the employees now, they can't sue employers in a personal injury action. They can only get benefits through the workers' comp system. So the employees get that benefit and the employer gets the benefit of not worrying about getting sued for personal injury action. But the flip side of that for them is the employer has to pay into the system to provide workers' compensation benefits. And even though the workers' compensation system has a lot of problems and there's some fraud, I think overall it's beneficial to employers because if you didn't have that, you would be facing a lot of lawsuits. You'd get sued for personal injury lawsuits, which could end up costing a lot more money, not just in terms of liability, but in terms of attorney's fees. So,
so then how about on the volunteer side?
Yeah, I think that would be more effective on the volunteer side because they're not an employee, so they don't have rights as an employee would. And in that situation, if a volunteer got injured on the job, the volunteer would have to sue the company, generally speaking. Now, I don't know if the workers' compensation system has been changed specifically for COVID-19. I don't think so. But generally speaking, if you're talking about a volunteer, the volunteer doesn't get workers' compensation benefits because the volunteer is not an employee.
Right.
I think a release of liability in that situation could be beneficial because if the volunteer tries to sue for personal injury or an injury that occurred at the work site, then that could be used as a shield potentially to say you waived, you know, any claim you have to suing us, that you volunteered knowing what the risks are and you assumed the risk. It's called assumption of risk. You assume the risk when you came and volunteered. And I would think, especially for you, if you're having volunteers helping, you know, to build houses, you probably want to release a liability for those people if you don't have one already.
Yeah, so we have a liability form that all of our volunteers sign, but it doesn't have anything in it right now specifically related to COVID. So the question is that something we need to add and what that language should look like?
Yeah, I don't think it hurts to add it. Whether or not that's enforceable, I don't know, but I think it has a higher chance of being enforceable than on the employee side. So yeah, I probably should add something to the effect. Well, you can call me later and I can help you prepare.
Okay, perfect. Thank you. Thanks. Sure. Good to see you, Ron.
Nice to see you. Anything else? Any other? Yes.
Along those same lines, my HR consultant sent me like this form that says like every time an employee comes in, which we only have 4 employees, so it's not a lot, but they sign that they didn't have a fever that day, that they're healthy. Does that even make sense to use, or?
Yeah, I think it makes sense. It doesn't hurt because, you know, you have an obligation to, as an employer, under what's called the General Duty Clause of OSHA, the Occupational Safety and Health Act, you have an obligation to provide a safe and healthy workplace. And so to do that, you should comply as much as possible with local, state, federal guidelines regarding COVID-19. So, you know, one of the guidelines is to make sure that employees self-monitor any COVID-19 symptoms and that they don't show up to work with those symptoms. And so having an employee sign a form saying they don't have any of the symptoms, they don't have a fever, they don't have a cough, I think that just goes, that just shows that you're taking your obligation seriously and you're trying to maintain a health and safe workplace as much as possible. You're not going to be able to comply with every single CDC guideline or any public health guideline, even though they're all basically the same, but you should try to comply with as many of the guidelines, workplace guidelines as you can to show that you are maintaining a health and
Ron, has COVID changed anything where, like in the past, if somebody went out on leave, on family leave, their job's secured, but is it my understanding that their duties don't have to be the same? They just have to still have their job and their benefits. Is that the same with COVID? After a massive furlough and you bring some of these people back, can you reassign their duties?
Well, so under the Families First Coronavirus Response Act, there is an obligation to hold the job open while the individual is out on the COVID-19 related leave. But it's typically wouldn't apply to less than 25 employees, but you have to be able to show certain things that I just helped a client out with this yesterday. There are 4 things that you're going to have to show in order not to hold open the job. Like one of the examples is that you have to try to find another alternative job that's similar. You have to consider that individual for the next, I think, almost a year. You have to consider that individual for a possible job that might come up. So there are 4 requirements which are kind of tedious to comply with, I think. So I tell my clients that if someone's out on leave, the emergency paid family leave under the Families First Coronavirus Response Act, try to hold open the job as much as you can. Now, if you can't because the job is gone, it's been eliminated, fine. But you should try to the best of your ability to keep that job open. And if it's not the exact same job, it needs to be a comparable job, as close with, maybe it's not the same duties, but the same pay, the same benefits, same seniority. You got to be careful that if you change the job completely and you pay less benefits, you pay less compensation, you didn't hold the job open for that individual.
Great, thank you.
Family Medical Leave Act and the California Family Rights Act. You have an obligation to keep the same job open or a comparable job. Yeah, with kind of this exact same benefits, same pay, same seniority. Maybe the duties are a bit different, but you don't want to go from being, the president of company down to a receptionist.
Right. Excellent. I got booted off for some reason. I came back on, so I lost my chat. Were there other questions in the chat that were not asked?
Well, let me ask you this: how many
I just didn't.
how many of you are having employees come back to work, or they have been at work? Most of you?
Yep.
Yeah.
Yes.
Okay, and have you implemented an appropriate plan to try to make the workplace safe and like have a plan about what employees are supposed to do at work, having PPE and those things? Okay.
Yep.
That's good.
Yes.
Yep.
And the CDC and the state of California, they have some very good charts and checklists and guidelines. I can send them to you if you want that. Really good guidelines to do to try to make a safe and healthy workplace. Yes.
So we've been open the whole time, and we have, I think, 4 people still on leave, and none of them are symptomatic. Some of them are just kind of nervous. Some of them are, they have family that have compromised immune systems, and we're under 50 employees. What happens when push comes to shove? And because we're running out of the 12 weeks. What happens when push comes to shove at the end of this period?
The 12-week period?
Yeah.
Well, and after the 12 weeks, they would be required to come back to work after the 12 weeks. So
at 12 weeks, we should just, because they haven't been paid for, for some time, right? Because we're under 50 employees. So at 12 weeks, we should just, or prior to that, send them a letter and say, look, the time is up, your job's here and available, we'll see you on this date?
Yes, but if an individual requests additional leave, and you have to consider additional unpaid leave, you have to consider that and determine whether or not to provide that extra leave. So You have the Family Medical Leave Act, and you have the California Family Rights Act, which provides 12 weeks of unpaid leave, right?
Okay.
A serious health condition of the employee and for some. And then under the emergency paid family leave, under the Families First Coronavirus Response Act, they have an additional reason to take 12 weeks off for individuals who need to care for their children. Now, I don't know, are your employees on these 12 weeks because they're taking care of their children? Or what's the reason? But yeah, they're on a leave.
I felt like this whole time has been a little bit the wild, wild west, but they, in some cases, they are taking care of children, and in one case, they live with a family member, and we've given people a lot of room to make those decisions. We haven't, you know, been harsh on anyone, but we're going to have to stabilize our staffing at some point here and find out who's left. So.
Right. So if an individual after 12 weeks is refusing to come back to work because they still have to care for a child, then yeah, you need to consider whether terminating that individual is appropriate. You know, it's hard for
nobody has symptoms or is caring for anyone with symptoms, so that's good news. So.
Yeah. Well, what I suggest is that I can help you offline with that, because it really depends on each particular person's situation. There may be an employee that maybe is sick and might need additional time beyond the 12 weeks. If it's just individuals who are taking care of children, then maybe you do terminate them, or maybe you give them the option of working from home if that's possible. So there are different things to consider.
Yeah.
Okay. As we get closer to that 12 weeks ending.
Yeah, well, it's getting pretty close. So, I mean, so, all right, thanks.
So Ron, can you talk a little bit about if somebody comes to work and they're sneezing and they're coughing and they're saying, I'm fine, I just have a cold, and you want to send them home just because everybody is looking at you like, do something. What do you do, and how do you compensate those employees?
Well, you can send the person home, and you can ask that the person seek medical assistance, maybe get even a COVID-19 test, which probably you should pay for as if you're requiring them in order to come back to work. But you can certainly tell them to go home and quarantine for a couple of weeks. So the question is,
you know, Ron, hold on, you're cutting out a little bit.
Yeah, can you hear me now?
Yeah, better now.
So I think that's yeah. So you can ask the person to go home. You can ask the person to see a doctor. You can ask the person to get tested, but I would pay for that test as the employer. And then you can request a doctor's note saying that person it's fine for that person to come back to work. But of course, then the question is whether or not under the emergency paid sick leave portion of the Families First Coronavirus Response Act, whether you have to pay for those 2 weeks of paid sick leave if the person maybe can't come to work because the person either has COVID-19, is being seen for potential COVID-19. But if you have fewer than 50 employees, then you can try to get out of that paid sick leave requirement. But yeah, you have an obligation, I would say, to send that person home if that person is exhibiting COVID-19 related symptoms.
Right.
And to make sure that person is healthy to come back to work. Because the worst thing you want to do is to allow a person who has COVID-19 to work at your workplace.
Right.
And and you may want to figure out who else that person worked around and worked with, and maybe people need to get tested as well. So it's probably best to send that person home, get that person tested, you'll pay for it. And if that person comes back positive, then that person needs to stay quarantined for at least 2 weeks. And then you need to find out who that employee worked with or was in contact with within 6 feet, who had kind of material contact with at work, and you should tell those people to go home and to get tested. COVID-19 can spread like wildfire pretty quickly.
Okay, other questions from the group? I have a non-COVID question. Have you run across staff that have wanted to take the day off to go and march or participate in a protest?
I have not had that situation come up specifically, but I know that it happens. And so your question is whether you have to allow them. You don't have to allow them to take time off of work to do it, but if they choose to do it outside of working hours, you really can't take any type of adverse employment action against them. There are some labor code provisions that give individuals the right to express themselves politically outside of work. And so even if one of your employees marches with, a white supremacist group, unless it significantly negatively impacts your business or the reputation of your business, typically people have the right to do what they want to do outside of work. As long as it's lawful conduct. If somebody engages in unlawful conduct, like if somebody drinks, drives, and kills somebody and gets convicted of a crime, you can terminate that person for violating the law. But it's hard to really regulate what people do outside of work that is lawful. Have you had that situation come up where someone wants to take time off of work?
I mean, we haven't. I'm just reading too much.
I mean, what have you read about that? I don't think there's a requirement that you allow them to march during working hours if they are scheduled to work that day. Have you read something different about that?
No. I just know that, the numbers have been, very high. A lot of people are out of work, so they've been able to participate on a weekday. But now that they're coming back to work, I would imagine they're still going to want to participate. And how should employers respond to that request?
I would say that if they're scheduled to work, they need to come to work if they want to keep their job. I mean, they can do whatever they want after working hours,
right.
But I don't think that they have a right to not come to work and to keep a job because they want to go protest. I don't think they have I'm not aware of any law that gives somebody a right to keep a job even though the person is refusing to come to work because the person wants to participate in protests.
Yeah. Okay. Rochelle asked a question here. Do you see that, Ron?
Yeah. So how do you suggest we handle the varied work week once we return to the office? Can you be a little bit more detailed? Like, can you explain to me what you're asking specifically?
Sure. My question is, half of our office lives in Los Angeles and half lives in Orange County. And we didn't mind working, that commute. I mean, truly didn't. But now we've had 4 months of 3 hours of joy added to our calendars each day. How do we handle when we get back into the office? Some people want to, work 4 days a week. Some want to work 5 days. Some are saying 980. Does everybody have to be on the same clock? And how do we handle if we have different schedules? Is there one rule for the hourly employees and one for salarieds? We're just trying to anticipate what if somebody says, well, I did so well working from home. Why do I have to come in 4 days a week?
Right. Well, yeah, this is a complicated area because you need to make sure that you treat people the same, not treat somebody differently from another person. But of course, the duties of the job are such that maybe some people can work from home and some people can't. So you have to kind of analyze each person individually and determine whether or not that person can continue to work from home efficiently and productively. I tell my clients, if somebody wants to stay working at home and the person is being productive and effective and there are no issues and the person can do the work at home, why not let the person work from home? I can tell you at my firm, there are some paralegal secretaries and attorneys who have told us that, they want to work from home for a good period of time. And we're letting them, as long as they don't have any performance issues, they're being effective, they're being productive, they can do the work at home. We see no reason why we can't let them work from home. So I think that's the perspective I try to give to my clients. that, again, if the person can do the work from home, there's no performance issues, you trust this individual, and the individual is productive and effective and efficient, why not let that person work from home?
So then we don't have to have a policy that says, I mean, everybody, it can be different
Yes.
for different employees.
It
Okay.
can be different if you are using legitimate criteria. So you can't say, you know, all women have to work at the office and men can work from home, right? That's discriminatory.
Mm-hmm.
So as long as you apply legitimate, valid business criteria, absolutely. There might be some positions where it can't be done from home. There are other positions that can be done from home. There might be some people who have performed excellently, that they don't have any type of employment issues, personnel problems. They can work from home, but there are other people maybe who haven't done very well, who have some performance issues, who you don't trust working from home. So that's that you might want to have them come to work.
Yeah, then there is one, I listened to an attorney who put the fear in me about the work from home, because she said, you know, it's good to have photographs of where they sit so that you know if it's ergonomically correct. And you need to make sure to check on their carbon monoxide monitors and their smoke detectors, and that they have a fire extinguisher. And I thought, geez, what are we putting ourselves, what kind of risk? Are those requirements, or are those her idiosyncrasies?
Those are not technically requirements. What I tell employers is, if you're going to allow people to work from home, tell them that it is up to them to make sure that they maintain a safe work environment. And if they have any concerns, to let you know, and that so that you can help them to make their workspace safe. You know, is the attorney you spoke with an employment attorney?
I would assume that she was, but that was in the very beginning of COVID, when everybody was,
Yeah.
you know, I just found her to be extremely conservative, and boy, that just really, we thought, okay, at that moment, everybody's back in the office. Nobody stays home. Everybody go back. So.
Yeah, there are a number of employment attorneys who are so cautious and conservative, and they don't take into account the practical business realities, okay? And the practical reality is that people are gonna be working from home, okay? And it's going to become a lot more common for people to work home. So yeah, you need to let the employee know that they have to maintain a safe workplace, but it's up to them, it's their home. And if they need any help, to let you know. And that's why I recommend that if you're gonna have people continue to work from home, that you have a telework agreement. And this agreement tells them what is expected of them. They need to, if they're hourly, non-exempt, they need to clock in and clock out. They need to take their meal breaks. They need to take their rest breaks. They're going to have to comply with all the company's policies and procedures, just as if they were working from the office. And they need to make sure that they also have daycare for their children, okay? That they can work without being unduly interrupted by their family, okay? That they can basically work at home the same as if they were working in the office. Now, of course, if a kid comes up to the employee and says, oh, mommy, I need help with something, or dad, I need help with something, that's fine. But you just want to make it clear to them that the same policies and procedures that apply to them at work, at the office, are going to apply to them at home as well. But the workplace is changing. More and more people are going to be working from home, especially now after a few months we've seen how it can be done so effectively and productively for a lot of people. Just be prepared to get a lot of those requests. And then you have to analyze each request separately. I mean, you can have a policy that, oh yeah, sorry, go ahead, Christy.
So you said that Newsom said if somebody gets COVID, it's now assumed they got it at work. What if they're working from home?
Well, they would likely be covered by it as well, because
They would what?
They would likely be covered by the workers' comp as well, because
they could be going out doing all kinds of stuff, as I am. How do you assume that they got it at work?
Well, that is the assumption now, at least for the next month or so. And it's up to the employer to prove that the individual did not contract it from the workplace, but contracted it from some other method.
So is the home considered the workplace?
Technically, yes, but I view that as there's a silver cloud, there's a silver lining to that cloud, because yes, there might be some increased workers' compensation costs, but on the other hand, you know that you're not going to get sued for the allegation that you made the workplace unsafe, that you allowed COVID-19 to somehow infiltrate the office, right? So you're protected now, because if an individual does contract COVID-19, they have to go through the workers' comp system. They can't sue you separately. So I think it's actually a good thing for employers overall, especially when you're in a situation that there's a lot of unknown, there's chaos. Attorneys are going to try to take advantage of this, and I'm not going to be surprised. I wouldn't be surprised if you see lawsuits against companies for failing to maintain a safe workplace, and an individual, let's say, died from COVID-19, and they're trying to sue the company for a wrongful death because they didn't take the necessary precautions to make the workplace as safe as possible. And that's where the workers' compensation system comes in. It's going to be very difficult for an individual to file that type of claim if the workers' compensation laws apply. So I would take it with a grain of salt. And I would definitely try to view that in a more positive manner. I think it helps employers as well.
It helps to add all those disclosures in the remote work agreement, as well as far as what the expectations are of making sure that their workplace at home is safe.
Correct. And typically what you say is that they need to maintain a safe workplace just as they would at work. And it's up to them. However, if they have any questions, concerns, or they need assistance, if they need you to purchase anything for them, then they need to let you know. Because remember, like if they need a new computer, new equipment, supplies, you have to pay for it as the employer. So basically anything that the employee needs that's related to the job, you need to pay for. There's a labor code provision, section 2802, which talks about how an employer has to indemnify an employee for all costs related to the employee performing his or her job for the employer. Yeah. And that's another area where I see some litigation. Employers, some employers haven't paid what they needed to pay. Like for example, like the internet, okay? If you need increased internet speed to handle all the Zoom calls and all the remote, cloud-based type of work, and if an individual, an employee needs to ramp up the internet speed from 50 to 100, the employer technically has to pay for that. And in fact, the employer probably has to pay for a portion of whatever internet service the individual has to pay some amount, like a reasonable proportion, maybe 10, 15 bucks, depending on how much the internet costs. But because courts have ruled, like with a personal cell phone, even if an individual has a pay plan for a personal cell phone, if the employer requires the employee to use the personal cell phone for business related purposes, the employer is required to reimburse the employee some portion, some reasonable amount of the cell phone. And I don't see why that logic wouldn't apply to internet service. I mean, I know with our firm, we've had to ramp up internet service for some of our employees because they didn't have strong enough internet to handle Zoom calls and cloud-based work.
Question in regards to that. We'll say I have a friend, but this topic with Labor Code Law 2802 was brought up to, I believe, the board and the CEO a couple times before, but it's not that it was ignored, it's just that we've been focusing on other things, and none of the employees really, they said that they were fine, they didn't need anything when I brought it up to them. But is it something that, my understanding was that that's the best practice, but are you saying that I have to by law do that, or to prevent a lawsuit if that was the case? Or is it something that now, I mean, I know we're almost towards the end of it, but is it something that I say, hey guys, this is something we have to do, so we start doing it now? Or maybe we don't need to do it at all if nobody's cares or wants, because they know our financial situation, and our staff are, they're just too amazing. They don't want anything from us. If anything, they donate to us. And so what do you think about that? Because I always want to do what protects us as the organization. But I also am a soldier, so.
Well, look, that labor code section is pretty broad. And if you as the employer are going to require an employee to perform work and need certain type of equipment and supplies, then technically, yes, you have to reimburse them for some, well, either you have to reimburse them for the full amount. Like if they buy a computer, that's for work, you got to pay for that computer. But when it comes to like a personal cell phone or a personal internet, you know, the law is fairly clear on that you need to reimburse the employees for some amount of it. It's not clear what the amount is. It's just some reasonable proportion based upon, it could be based upon use. Like if they use the internet 5 hours a day, or let's say 8 hours a day out of 24 hours, maybe you reimburse them 1/3, you know, of the internet. So I would say the law basically requires that, but I understand your situation. It's not practical for some employers to do that. And so if you don't have the money to do it, you don't do it. Is there a risk that you could get sued? Yes. The good news is you're only talking about a few employees, right? You don't have hundreds of employees.
No, it's only like four or five.
Even if all 4 of them sued and they said, we were owed, you know, $20 a month for the past 4 months, I mean, you're not talking about a ton of money, right? So you have to weigh the costs and benefits and the risks. If it's not feasible, practical, you don't have the money, then don't do it. You know, but if you can afford $5 or $10 a month per employee, at least it shows that you try to reimburse them some amount of money for the expenses they incur while working from home.
Thank you.
You know, it's more of a concern for bigger companies. You know, if they have hundreds of employees that they are not reimbursing, then you're talking about a lot of money. But in your situation, only 4 or 5 employees, you're not talking about a lot of money, even if you do get sued. And it sounds like you have a pretty good relationship with them, and the chance of them suing you is pretty slim.
We do. I even told them, you know, that I wanted to do this for them, even if it was $20, $25 for both their cell phones, and then $25 for internet, so $50 each. And they were like, no, we're good. I did provide them with things I didn't have, like either a computer, a laptop, keyboard, whatever they needed that they could take, that they had, they took. And but I felt compelled and said, hey, this is what, you know, I want to do. And they were all like, no, there's no need, you know, we need the money.
Even if you say that, you know, if you can afford to pay them $10 a month, then you should do it. Even if they say no. They're saying no now, but if you terminate one of them, right, and that person gets upset, then all of a sudden they're going to say, you never provided me with a proper reimbursement. Right. So, you know, if you can afford something, then pay it. If you can't, then don't, and you know, you'll just have a higher risk of a potential lawsuit. But again, you're talking about 4 or 5 people, so it's not a ton of money.
So do you recommend that I retroactively pay, or just moving forward?
If you want to be 100% safe and cautious, yes.
Yeah. Okay.
And again, I don't think you're talking about a lot of money. You're talking about, you know, maybe let's say it's $10 a month. That's $50 a month times 3 months, 4 months. It's not a lot of money.
Yeah.
And it could save you some headache in the future.
Thank you.
Yep. Yes,
Ron, I have a question regarding the vaccine. Let's assume that they find a vaccine in the, you know, September-ish or fall at some point. I know it's wishful thinking, but let's say they have the vaccine, even if it's after the first of the year. What can employers do to encourage their employees? Is there anything that they can do? What happens if an employee says, I'm not coming until everybody gets vaccinated? I can just anticipate there could be some major unease during this time.
That is a good question. And to be honest, I don't know what the answer is. And I'm not sure that has been addressed, because we haven't seen a pandemic like this in 100 years. The last one was the Spanish flu back in 1917, 1918, where it was a global pandemic. and businesses had to shut down. And what's happening now is very similar to what happened 100 years ago. They shut down a lot of public gatherings in stores, restaurants, etc. So I don't know if that has actually been addressed. That might be kind of a novel area of law. I mean, my gut instinct tells me that if the vaccine is found to be effective and there isn't a risk of dying, my sense is employers could probably require employees to be vaccinated before they come into the office. But if the efficacy of it is not conclusive and there's a chance of getting sick, I don't know if an employer could force that on employees. So, but you raised a good question, and I'm going to look into it just because I'm curious.
Yeah.
Yeah. I mean, for example, now employers can check the temperature of employees before they come into the office, which granted is far less invasive than a vaccine. But the employers now can require a COVID-19 test before coming to work if you suspect that the employee either has COVID-19 because of symptoms or that the person has been exposed to somebody with COVID-19. So you're allowed to do that. But again, testing is not as invasive as actually getting a vaccine. So.
Thanks. I was just curious if you had heard anything.
Yeah, I'm curious too. I'm going to look into that. I'll let you know if I find anything.
Any other questions for Ron? It's always so helpful. You're so easy to ask questions too. We so appreciate this.
Well, I appreciate it. When it comes to labor and employment law, you have what the law says and requires, and then you kind of have the practical business realities of how things are done. And you have to kind of balance the two. Like that one other attorney that someone was telling me about, some of these attorneys, they get so freaked out by all the labor and employment laws that they are too cautious and too conservative. But of course, look, I tell my clients, there's a risk with this course of action, but the risk is probably low. So you can pursue this course of action, even though it's not technically compliant with the law, but as long as the employer recognizes that there is some potential liability. But California is its own republic when it comes to labor and employment laws.
Right. Like I was curious if any of the employers are even on the call, like have you been asked to pay for overtime? You've got somebody working from home and you really have no way of knowing what they're doing. And I wonder if some of the hourly employees are asking for overtime.
Well, that's why you need to ensure that hourly, non-exempt employees clock in and clock out. They put their time on a time card. And if they don't, then you discipline them. And if they continue to refuse to do so, then you can fire them. That is the way that you can ensure that employees at home are getting paid for the hours that they work. And if you see unapproved overtime, then you can discipline for that. Now, unfortunately, you have to pay for that overtime, but you can discipline the employee and say, if you, again, work overtime that's unauthorized, we'll pay you for it, but we're going to have to fire you. You can only work overtime if we authorize it. So that's why it's so important, this telework agreement, so that the employee knows exactly what he or she is required to do.
I have a question that's a little bit off topic, but it's similar to the volunteer acknowledgement of risk. So we have our learning groups where we bring everybody together, and we're able now to convene them off-site. And would it be beneficial for us to have an acknowledgement of risk, even though we're gonna social distance them off-site to meet? Would it behoove us to have an acknowledgement of risk saying that they wouldn't hold us accountable?
Now, these are non-employees. They're not.
Non-employees, they're participating in a program.
It doesn't hurt. I mean, maybe it won't help eventually, ultimately, but it can't hurt you. It can only help. It's different in the employee context. It could hurt you because if you try to get an employee to sign this release and the employee says no, and you fire the employee, that could be problematic. Whereas in your situation, if you tell these people, if you don't sign this form, then we're not going to have this program. You're not going to be able to participate in this program. So that's not unlawful. But if you terminate an employee for refusing to sign a release that could be void against public policy, then you've got a potential problem.
Okay.
So for the volunteer situation, for Robin, the situation that you're talking about, it can only help to have a release of liability, waiver of liability. Just want to make sure that it's worded properly, that it contains all the appropriate bells and whistles.
Patricia had another question in here, and I don't know if this is a wrong question or I don't know if Janet is still available. But if you want to read that PPP question, reimbursing employees.
Yeah, so in relation to what I just asked regarding Labor Code 2802, it just popped into my head because we also received the PPP loan. So I have a PPP question in the reimbursing employees for cell phone and internet. Can we include what we paid employees for cell and internet under utilities for the PPP loan?
That is a good question. I don't know the answer to that. I know you get reimbursed obviously for payroll, right? For the wages that you pay. Can you get reimbursed for non-wages? My gut instinct probably tells me no, but I would need to look into that. I don't know off the top of my head.
Janet, are you available? She might have stepped away from her. Patricia, would you? Oh, Janet, are you there?
Yep. Can you hear me?
Yes, we can hear you.
Yeah, I'm having some internet issues. That's why I can't do my video.
Yeah, that's okay.
So, real quick before you ask your question, I remember I sent an email to a client dealing with this issue and I found it. And so PPP loan proceeds can be used for payroll costs. And a payroll cost consists of salaries, wages, commissions, payments for vacation, parental, family, medical, or sick leave, like a severance, group health benefits, retirement benefits, and state or local taxes. So it does not look like you can use the PPP loans to cover reimbursable employee expenses. That's just kind of the 30,000 foot overview, I think. I don't know specifically, but just looking at an email I sent to my client, I think that's probably the right answer.
Yeah, and I would agree with you because it depends what those expenses are, and you would have to, they would be the bottom line expenses. So I would, it has to be those, payroll, utilities, rent and or interest on mortgages.
Yeah.
Thank you. Thank you. Okay, well, it is 4 o'clock. Ron, once again, you are awesome. Thank you. Everybody give Ron a big round of applause for an hour of his time.
If you have any questions, Robin, I think you can provide them with my contact information. And if you have any other questions, concerns, let me know.
And Rochelle, I can share the remote work agreement that I have with you. Maybe I can forward it to Robin and then Robin can share it with you.
Yeah, and I can send to Robin a sample telework agreement that I have that you can look at.
That would be great.
Sure.
Thank you.
Send it to either one and we'll send it out to the group. I put in the chat earlier the YouTube channel. Otherwise, just go to YouTube and just put in Fieldstone Leadership Network. So this call, you can access information and you can share it with your colleagues. Ron, we might ask you to come back next month because I'm sure we'll have more questions in a month from now. But we really appreciate your time. Everybody be well. Tomorrow we have another amazing webinar. Dawn's organization is going to present on building a culture of anti-racism. So I hope to see you all tomorrow as well. Very informative week and we're here for you. So thank you, everybody.
Thank you. Thanks, Ron.
Take care.
Thanks, Robin.
Bye.
Bye, guys.